information from her, and I will be requesting counsel be appointed.
So then we will set this matter for a probable cause conference on May 30th, 2024 at 10 o'clock, and a preliminary examination if need be for June 6th, 2024 at 1 o'clock for now. So then, Mr. Zwocki, do you have any information you want to provide this court regarding the issue of a bond?
Yes, Your Honor. I would indicate to the court that my client was born on December 5th of 1988. She has no pending charges. She's not on probation. She's not on parole. She has no felony record, has no misdemeanor convictions, so a completely clear criminal history. She is employed full-time, works at the State of Michigan Secretary of State's office. She has worked there as a clerk for the last year and a half. She is a lifelong resident of Michigan, presently resides with her fiance and her 4 children. She has children ages 13, 11, 7, and 1 year of age. She is also presently pregnant, and I would ask the court to consider setting a reasonable bond.
Thank you, sir. I know we have Ms. Zemla here on behalf of pretrial services as well, and I know I've received a report from pretrial services. So, Ms. Zemla, is there any additional information you'd like to give the court?
Your Honor, while conducting the pre-sentence for the pre-trial release recommendation, I did come across different information that I felt the court should be aware of. I would ask the court to consider the fact that there were victims involved in the community safety. There were notes that there was a mostly empty pint of alcohol within the defendant's purse. The defendant had left the scene of the accident, which leaves concerns that there could have been more victims had the agencies not responded as quickly as they were able to. That there was a PBT that was administered at the jail. That result was a .183. There was also notes in the report that there were prescription medication bottles found within the vehicle in the defendant's purse. I would ask the court to take those factors into consideration. I'm not sure if our prosecutor here has any other information.
I'll give Ms.
Oh, sure.
Martinez a
Okay,
complete
I wouldn't
opportunity
want
to
to
address the
overstep,
court
sir.
as well. Okay, thank you so much, Ms. Zemla. And Ms. Martinez, I'd be glad to hear from you as well.
Your Honor, pursuant to Michigan Court Rule 6.106F, the people have reviewed the information in this case, including her criminal history. Factors we think the court should consider is her record of appearance or flight to avoid prosecution. Please note that several of the charges, felony charges issued here, involve leaving the scene of an accident involving serious impairment and death. Second, under subsection C, we would like the court to consider her history of substance abuse and or addiction. As Ms. Zemla pointed out, there was an open bottle of Crown Royal located in the defendant's purse. She was the only occupant and the driver of the vehicle, as well as 2 prescription bottles of antidepressants, which were also prescribed to her in her possession at the time. The antidepressants are also relevant due to the defendant's mental condition pursuant to subsection D. And under subsection E, the seriousness of the offense charge and probability of conviction and likely sentence. Here we have multiple victims, including the 2 deceased individuals, but we have other victims ranging in ages of 2 up to 60. And as their medical conditions are changing, and as we become aware of more information, these charges could change to become more serious over the next few days. So there may be additional charges. Further, for probability of conviction and sentence, the Clinton County Sheriff's Office apprehended the victim less than 3 minutes after the call came out. Her car was located with severe damage to the front passenger side, consistent with witness statements, as well as blood, hair, and other tissue on her vehicle. We have worked on search warrants to compare that tissue and blood to the victims in this case. And we think because of the alcohol use, the flight, the number of victims, the age of those victims, the amount of charges that are currently charged before the court, as well as additional charges that could be added as we become aware of the nature of the injuries, of the sheer amount of victims here, we think she is a serious risk to the public. Witnesses were located and came forward to describe her erratic and dangerous driving both before and after she hit this group of people. And we would like to request that based on all these facts, if the court does provide a bond that she can post, that based on the level of intoxication and the egregious conduct here, that she be required to wear a scram tether to ensure that she is not consuming alcohol if she's allowed back out into the public. We would request a bond of $500,000 cash surety.
Okay, thank you, counsel. So, as,
Nothing further, Your Honor.
okay, thank you, Mr. Zawacki. As Ms. Martinez has indicated, this court has to look at Michigan Court Rule 6.106, and when the court looks at subsection F regarding statement of reasons for the court, if the court were going to impose some type of cash bond here, Ms. Martinez has cited a number of the factors that the court has to take a look at. And one of the factors that she talked about was defendant's history of substance abuse or addiction. So other than the fact that there is a bottle, open bottle of alcohol in the vehicle, and there are 2 prescription bottles for antidepressants, is there any other evidence that would show that the defendant has some type of addiction here?
Not from the criminal history, Your Honor.
So here, when the court is looking at setting a appropriate bond, especially when the court is looking at setting a cash bond, of course, both the United States Constitution and the state of Michigan's Constitution provide that excessive bail should not be required. Money bail that is excessive, if it is greater than the amount that's reasonably necessary to adequately assure that the accused would appear and adequately sufficient to protect society. That would be People versus Edmund, 81 Mishap, 7/43/1978. So the broad factors that the court has to take into consideration when fixing a bond would be the seriousness of the offense charged, the protection of the public, previous criminal record, and the dangerousness of the accused, and the probability or improbability of the defendant appearing. Of course, subsection F lists a number of factors that the court needs to take into consideration in determining what might be an appropriate bond, whether the defendant has any prior criminal history, including a juvenile offense. Here in this case, the defendant does not have a prior criminal history. The defendant's record of appearance or non-appearance in court proceedings or flight to avoid prosecution. Well, the court is not aware of any history that the defendant has of non-appearance in court proceedings, and apparently the defendant doesn't have any criminal history at all. Now, the prosecutor has mentioned subsection C, which would talk about the history of substance abuse and or addiction. And in this case, allegedly there's a PBT result of a .18, which would be over twice the legal limit in this case. There was also open alcohol that was found in the vehicle, along with prescription drugs that were found in the vehicle. The court could take into consideration under subsection D the mental condition, including the character and reputation of the defendant for dangerousness. Under section E, the seriousness of the offense charged, and the presence or absence of threats, and the probability or likelihood of a sentence in this case. And of course, the defendant's employment status, history, financial history under subsection F. And under subsection G, the availability of community members who would vouch for the credibility or who would be willing to monitor the defendant in this case. So in this case, the court has a number of very serious allegations. And I understand that the defendant's pled not guilty to these allegations and that there's a presumption of innocence here. What the court knows for sure is that we have two individuals that have died. That two people have lost their lives prematurely. And the only kind of issue there is whether or not there was some kind of criminal agency that was the cause of that death. And then we have other multiple felony allegations involving leaving the scene of the accident. So here, about when it comes to the factor of probability of appear or not, the fact that the defendant allegedly left the scene, engaged in flight, would be an important factor for this court to take into consideration. Because there's an allegation that there was a serious accident that involved the death of two individuals so far, and serious injuries to numerous other individuals. And rather than stopping at the scene of the accident to make sure that people weren't hurt or seriously injured, allegedly the defendant chose to flee the scene. Again, we're not talking about just a victim, we're talking about allegedly multiple victims. We're talking about numerous serious felony allegations. And I think here, due to the fact that the police had encountered the suspect within 3 minutes of the time that this call came in, was incredibly fortunate, because based on the information provided to the court in the probable cause swearing, the officer, after observing the suspect vehicle, saw the vehicle leave the roadway, drive through the grass, then come back on the road, and allegedly cross the center line. At that date and time, there was some very dangerous driving allegedly that was happening. It's very fortunate that the officers happened to be able to come across the suspect in such a short period of time. So I think looking at the likelihood of a conviction, that's another factor the court has to take into consideration, looking at the dangerousness of the defendant and the allegations here, and the dangerousness of the alleged driving on the date and time in question. It would call for, in this court's opinion, a substantial bond in order to make sure that society is sufficiently and adequately protected. So the court is going to set the bond at $1 million cash or surety. Should the defendant post that bond, the defendant would have to immediately report to pretrial services. And the defendant would have to be fitted with a alcohol scram tether. The defendant also would be subject to random testing for any type of illegal controlled substances or any type of intoxicating substances. The defendant's not to have any contact whatsoever with any of the victims in this alleged victims in the case, either directly or indirectly. So, Ms. Semler, would there be any other recommendations from pretrial services as far as potential bond conditions?
Your Honor, I would just reiterate that the defendant shouldn't leave the state of Michigan without permission of the court and not to commit any other crimes while on release status.
Okay, so ordered. And Ms. Martinez, is there any other bond conditions that would be of concern for the people?
No, thank you, Your Honor.
Okay, thank you. So, Mr. Zawacki, is there anything further I can do for you today, sir?
No, Your Honor, thank you.
And Mr. Zawacki, you'll be contacting Mr. Pellerito regarding the defendant's need to have an attorney appointed to assist her?
I will do that, Your Honor.
Okay, thank you. And Ms. Martinez, is there anything further I can do for the people today?
No, Your Honor, thank you.
Okay, thank you all for being here.
Please to get their microphones
Sure.
off the podium.
Oh,
Yes.
no problem.
Right, that was in St. John's, Clinton County Court, where the woman arrested for the deadly hit and run accident over the weekend has been arraigned. Our Erin Bowling, you may have seen her there just a little bit. She was in the courtroom. She's going to have more on this coming up on News 10 at 5 and at 6. Plus, we have everything on our website, WILX.com. I know there's a lot of people watching on Facebook and YouTube right now, so make sure you check out the link that I put in the chat, where a lot of you guys are asking questions. That's where you can find the latest information. Again, the woman who is arrested for the deadly hit and run in Clinton County over the weekend has been arraigned in a Clinton County courthouse. Until then, make sure you stick with WILX for all of the latest, and thank you for tuning in.